Test, test, test. Test, test, test. Test, test. Test, 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 test. Test.
Good afternoon. I believe we are ready to go. My name is Matt Lepore. I am the director of the Colorado Oil and Gas Conservation Commission. We are here this afternoon at 1120 Lincoln Street on the 8th floor for a stakeholder meeting on a Flowline rulemaking. I want to thank you all for being here. Pretty good number in the room. We also have a video conference available via Zoom. And if I was smarter, I could probably see how many people are on the Zoom, but there's a limit of 100, so we'll see how we do there. And we are webcasting this as well, so there's audio available via the web. I would ask if you're participating by Zoom, but really only want to listen and not be able to participate by commenting or asking questions, if you don't mind switching and doing it by the webcast, that might free up a space for somebody who is more interested in participating. Just as a preliminary housekeeping matter, I would need to say that the rules of the Administrative Procedure Act do require us to have a record of those who attended today so that we can provide you with notice of the rulemaking when that notice is published. So there were sign-up sheets when you came in. We would ask that you please sign in and give us your email address so that we can provide you with that APA notice. For those of you participating by Zoom, it is my understanding that there's a space when you register to attend the Zoom that you could add your email. If you do that, it is also my understanding we will have a record of that email. And again, therefore, in that way can fulfill our obligations under the APA. So I appreciate that. I want to introduce the staff from the COGCC who are sitting up here with me, and then I'll talk about our agenda for today, and then I'll dive in. So I'll just start to my left, and to my immediate left is Julie Prine. Julie is our very new Hearings and Regulatory Affairs Manager. So welcome to Julie. And Julie is also going to serve as the Hearings Manager for this rulemaking once we sort of get to that stage of the rulemaking. And I will talk a little bit more about that in a second. Next to Julie is Mimi Larson. Mimi is also relatively new to our family. Mimi is one of the Assistant Attorney Generals at the Attorney General's office, for whom we are her client, or something like that. She is our counsel at the Assistant Attorney General at the Attorney General's office. To my right, Stuart Ellsworth is our Hearings Manager. Most of you know. Sorry, Engineering Manager. Wow, we can have a big debate of whether that was a demotion or a promotion. Engineering Manager. Next to Stuart is Mark Schlegenhoff. Mark is a supervisor for our Flowline Integrity Group. And next to Mark is Elise Hazard. And I will get Elise's title wrong if I try to say it. So Elise is also in the Flowline Integrity Group with Mark. So they are the subject matter experts. And obviously have been very involved in the process that resulted from the NTO, the notice to operators, and things like that. So what I'd like to do today is start with sort of a process and timeline for the rulemaking, so everybody knows where we are, where we're going, and hopefully where the finish line is. And then I will go through the staff scoping document, just an overview of that, which I don't think will take a whole long time. And then we will open it up to audience questions or comments. I will say that while I go through the scoping document, if you have a burning question, by all means, chime in. On the other hand, like I said, I don't think it'll take very long to get through that document. So I guess if you think you can hold the question to the end, that would, that works too. I'm going to direct everybody's attention to the website, or to the screens on the room, which show the homepage of the COGCC website. And on that homepage, you see a link for Flowline rulemaking information. That link on the homepage will be there throughout the duration of the rulemaking, and that's, not surprisingly, where you should go to get up-to-date information about what's happening with rulemaking. So somebody click on that link for me. Thank you. And right now we have 2 entries there, the timeline document that I will talk about in a second, and then the scoping document that we'll use to kind of structure this meeting around. We will add documents to that link as they are generated. So for example, as I will tell you here in a moment, we will have a form for those of you who wish to be parties to the rulemaking. When that form is available, which ought to be in the next 48 hours-ish, you'll find it there as well. It's there now. Look at that. Okay, fantastic. Similarly, as we generate hearing officer scheduling orders or such things, you'll be able to find them there. As we generate draft rules, you'll be able to find them there. So the website is always sort of our touchstone of where information can be found. So with that, I want to start. I will go to the schedule, which I think is in one form right there. And we are at September 21st at the first stakeholder meeting, one of 2. Second one is this coming Monday here in this room, also on Zoom, just as this one is, Monday at 1 p.m. That's the 25th of September, second stakeholder meeting, 1 p.m. After that, our present intent is to file a notice of rulemaking on October 15th, and that goes to the Secretary of State. That notice of rulemaking will have a draft set of rules with it. We will send all of you who give us your email address a notice of that rulemaking as well, and we will post those draft rules on our website, as I've just described. After we send it to the Secretary of State, they publish it in the Colorado Register. That will happen 10 days after we submit it to them, or October 25th. The next real deadline for any of you to be concerned about is October 30th, which is the deadline to file party status. And as I said, you can do that with a simple 1-page form. I left off a deadline, and I want to talk about this because this one does matter as well. We're asking that if you have comments on the scoping document, comments in response to things that are said today, that you submit, and you want to submit those in writing. You're here today to offer those up verbally, but if you elect to submit something in writing, which you are welcome, if not encouraged to do, we would ask that you do that by September 29th. And the main reason for that ask is that so we can have the benefit of those comments as we sit down to really draft rule language. So not a hard deadline. We're not going to reject them if they come in later than that, but the extent to which they get thoughtful consideration and potential inclusion in some way in the draft rules, September 29th would work for us. There is an email address to which you can submit those comments. That email address is DNR_OGCC_rulemaking, DNR_OGCC_rulemaking at state.co.us. So it's the same email format that we all use, but it's kind of that group address. All right, so we get to October 30th, party status. The schedule after that will be set by the hearing officer and sort of by, we'll figure out times for parties to file statements, etc. And then we are targeting and hope to be able to keep on target for a December 11th, 12th hearing on the rules. So just to be clear, December 11th and 12th is our already regularly scheduled commission hearing, and that's here in Denver. And I've asked the commissioners to keep their calendars open for December 13th. So that's just a heads up. How much we can get done in 2 days depends on our regular hearing docket, to be frank. And how much time we need for a rulemaking hearing on this will depend on a lot of things between now and then. But it's far from it's well within, it's well foreseeable. I knew I could get it out, found some lawyer word to use there. Reasonably foreseeable that we would need more than 2 days to do our regular hearing and a rulemaking hearing in December. One more thing I want to say generally, and then I'll take a breath and ask if you have questions. But I do want to differentiate between stakeholder and party. I know for a lot of you this is second nature, but for a lot of you it's not. Stakeholder is, there's everybody who's interested in this, who wants to show up or participate or send us a comment, is a stakeholder. There's no requirement, prerequisite, or anything else to be a stakeholder. You're all stakeholders. To be a party, you need to file this one-page form, which is, we sort of refer to as a request for party status, but that's really all you have to do. So if you file the form, you become a party. Parties have certain rights that stakeholders will not have once we get into the more formal part of this, and those rights include the right to file a statement commenting on the draft proposed rules, the right to file alternative proposed rules, the right to respond to other parties' filings, and the right to participate as a party at the rulemaking hearing. Stakeholders are welcome always to file written comments under our Rule 510. So you can file a 510 statement, even if you're not a party. But if you really want to get down into the trenches on this as a party, you want to file that party status. So that's just the distinction. So again, those party requests are not due until October 30th, so everyone can participate as a stakeholder until then. Any questions about any of that? In the back row, Mr. Seaman.
Thank you, Director Laporte. Can you speak to the Monday stakeholder meeting? Is that a identical meeting to what you're doing here today, or is it iterative? Is it here, et cetera? Thank you.
You're welcome. Thank you for asking. So first, it is here. That's the easiest answer. And second, my sense is that it will be somewhat redundant. I think we might have a better answer to the question at the end of today. If there are just rooms full of questions and dialogue and things, and we can't finish this by 4 o'clock, then I would say where it's, Monday looks more like a little bit of a continuation, an extension. If we wrap this up at 1:30 or 2, then I'm going to say, we'll do it again Monday for those that couldn't be here today and see what happens on Monday. Are we monitoring Zoom? So I should pay attention to you. No questions or comments from Zoom? Okay. Okay, thanks. All right, I've already made a mistake, which I will now correct, which concerns the address, the email address. Well, I can always hope that they all go into cyberspace. Okay, DNR_COGCC, we're positive. We're going to double check. Oh, let's just hold on a second. Come back to that. All right. DNR_COGCC dot, not underscore, dot rulemaking at state.co.us. We'll make double, triple sure and post it on the website too. Okay. I'm going to turn to a relatively brief review of the scoping document that has a September 8th, 2017 date that has been posted on the website since that date. I'll start here. This rulemaking relates to and arises from recommendations from Governor Hickenlooper about actions to be taken following the Firestone fire explosion fatalities in mid-April. The governor had a series of meetings with a wide array of stakeholders, interested parties, to hear from them and get their assessment of what would be appropriate future steps with respect to safety around flow lines, etc. And he boiled that down to 7 recommendations that he announced in late August. One of those recommendations was for COGCC to review and make appropriate revisions to its flowline rules. The second was to enhance the capabilities of the Colorado Utility Notification Center, better known to most as the 1-call or 811 lines, as it relates to oil and gas operators and flow lines. So just a word on that. Our COGCC's rules currently require operators to register with 811. However, 811 has 2 tiers of registration called Tier 1 and Tier 2. Our rules do not currently specify which tier operators are required to register for. In our estimation, Tier 1 is a more robust process, and the intent is to require, with this rulemaking, that operators register as a Tier 1 operator. I will say that we understand that it is possible that in the not too distant future, 811, that entity may change its operation, so there may no longer be a Tier 1, Tier 2. But to the extent there is, we think it would be prudent for all of our operators to be Tier 1 members, and that is something we can do by rulemaking and intend to do with this rulemaking. Second aspect of that is we want to make sure that our rules are aligned with 811 regulations, requirements, et cetera, in terms of capturing for reporting all things that we think of as flow lines. Again, there are some perhaps expectations that 811 will be engaging in potentially legislative action to modify its existing structure somewhat. I would say that COGCC would pay attention to those, but we're not driving any of that. That's up to them. Some of those changes might deal with 811's ability to enforce in situations where their members are not responsive to requests for locates, as an example. That was an issue that was raised to COGCC during the NTO process and during subsequent conversations that we've had with stakeholders. You just have to understand there's a limited ability of COGCC in terms of rulemaking versus a legislative change to what 811's guiding statute is. So I'm going to then turn to more directly the scoping document itself and talk about more direct changes to our existing rules. Our intent with the scoping document was to stimulate thought and in conversation and recommendations, frankly, from the stakeholder community. So we've got, really a pretty succinct couple-page outline here. But we also attach 2 documents to that, which are on the website. And those 2 documents are a Flowline guidance document. It's an operator guidance document that's, I think, 14 pages long. And then in addition, the second document is what we called our Notice to Operators Frequently Asked Questions document. And the FAQ document was generated as operators were implementing the notice to operators that we issued immediately in the wake of Firestone. So the FAQs are a lot of clarifying statements or explanatory statements from COGCC, largely in response to operator questions, again, as they implemented the NTO. It's a useful document because it clearly provides some insight and perhaps guidance into our thinking in response to questions operators were asking. Some of those questions, just to give you a flavor, revolved around flow lines that are connected to a pressure source at one end, but which terminate into an open tank and therefore don't really have a pressure on them, and how we thought those should be handled in sort of an inspection and integrity testing function. There were other questions around risers for flow lines that are not currently in use, that might be on a multi-well pad where there is a clear present intent to bring those into service in the near future, and how those should be addressed. So that's just 2 examples that come to my mind about things that we were asked, that we provided guidance on, that I think if those topics are on your mind in this rulemaking, start there if you want to know probably which way we're leaning. Okay, with respect to specific topics for this rulemaking, this really starts at the bottom of page 1 of the scoping document, dramatically with definitions. So we will likely have to change some definitions, as we always do when we have rulemaking. Interesting sort of list of potential definitional changes that might come into play here. One of those is abandoned lines versus active lines. I think through the NTO and the FAQs, what you see from COGCC is our leaning to, we want a very bright line dichotomy. Your lines are either active or they're abandoned. There's very little middle ground. So that's kind of where we want to be. And if they're active, they have a certain configuration. And if they're abandoned, they have a different configuration. And that different configuration looks like either they're locked out, tagged out, and very clearly marked for some period of time, after which they are abandoned pursuant to the 1100 series rules, and risers, especially risers related to remote or offsite flow lines, have been cut and below grade. So just where we're headed on that. A lot of questions were raised during the NTO about a distinguishing perhaps between flow lines that connect things on the same well pad compared to flow lines that connect things with a remote production facility distant from the well pad. I think that's a topic that we are interested in, and we may seek clarity through the definitions. And there may be a ripe area for some conversation as we go forward. One of the things we've said pretty consistently since the NTO was issued is that we want to eliminate the low pressure line exception in our current rules. I think you can count on that, with the understanding that in some cases there are gravity fed lines, or lines, as I mentioned before, that open into that terminate into an open tank, and we will figure out a way to elegantly deal with those without preserving the existing low pressure line exemption. Produced water gathering systems, we believe, are flow lines, and we intend to regulate them as such. those produced water lines carry E&P waste. They have hydrocarbons in the water. Sometimes they're very large and move a lot of water over a lot of space and have lots of different components. We understand those complexities and will seek to appropriately accommodate those complexities, but we do want to make sure everyone understands they're within the Flowline rules. So there's some other things referenced in the scoping document. I won't belabor any of those, but you know, you can expect to see some changes in the definitions. Then the 1100 series rules are in fact the Flowline rules. Currently, the 1100 series uses the word pipeline throughout. We're going to change that to Flowline because they're really Flowline rules. So you'll see sort of a global change there. Other changes we anticipate making to the 1100 series are listed again starting at the bottom of page 1. There are some existing engineering standards that Mark and Stuart could talk and Elise could talk a lot more about than I can, but there is sort of an intent to incorporate some of those existing standards where they are applicable. Just bring those into our rules instead of writing lots of new verbiage ourselves. Say that compliance with this standard in this circumstance satisfies these rules. Be kind of my vision. Do you want to add anything to that? Okay. Somewhat relatedly, since the current rules were written, the technology has evolved in terms of the capability of continuous monitoring systems. These are applied, certainly to my knowledge, somewhat wide usage where we have these larger produced water gathering systems that I referenced a minute ago with lots of component parts covering lots of space. And the technology exists to monitor the pressure within those systems continuously using remote SCADA system technology and other technologies. We have allowed those kinds of systems typically by a variance process today because our rules don't specifically allow those. We think modifying the rules to allow those by rule in appropriate circumstances makes sense, not to eliminate other existing acceptable testing methodologies, but simply to bring those into the fold where appropriate. I've touched on removing the low pressure exemption. Count on that. I've also touched on the distinction between remote flow lines and on well pad flow lines. And then I want to talk here about lockout, tagout requirements that were part of the NTO, where risers are currently not in use, but there is an intent to bring them back into use. That will likely manifest itself in this Flowline rulemaking. I've touched on 811, and then the last one on this list of 9 in the scoping document is improving flowline abandonment requirements. There are 2 things specifically that I'll say about that. One, in the NTO, what we sought to accomplish with the NTO was to have all abandoned flowline risers cut off below grade, which is what is required by our current rule. But that current rule only took effect in, I've probably forgotten the date now, 2001 maybe. So anything that was abandoned before that, it was okay to leave the riser up out of the ground. And I think one of the things that operators discovered as they went through the NTO process was there was a lot of those out there. So what we want now is to codify that NTO requirement in our rule so that the rules say, regardless of when that flow line was abandoned, now it must be, the risers must be cut off below grade. So just codifying, if it was a perfect world, there would be none of those left because operators dealt with them all in the 60 days following the issuance of the NTO. But we just want to go ahead and put that in rule make it be the way the world is as we go forward. The second thing we're talking about with abandonment is I won't be surprised if there's a conversation around whether lines should be allowed to be abandoned in place. That's what our current rules allow. I think where we are leaning is that we would continue to allow that, provided those lines are filled with a cement slurry type material. And we are even wanting to probably go as far as having that be a colored cement material by rule. And not, spoiler alert here, yellow is the color that we're thinking of. You can comment on that in your submissions if you don't like yellow. But yellow is what 811 currently uses to identify gas lines, so it sort of made sense to us. And the idea being here that, X years from now, backhoe hits a line that it didn't expect to hit, and if it cuts into that line and sees that there's yellow fill material, helps them understand what they're dealing with. That's what we've got on the 1100 series. We anticipate some changes to the 300, 600, and 700 series. I'm going to touch on those really quickly. Under the 300 series, we will probably add a requirement that operators of produced water gathering systems that are moving E&P waste register with COGCC. Registration means that we can assign a facility number to that system. Right now, we don't have that capability, and it raises lots of challenges for us. It's just a way for us to know that it's out there. We'll probably have a conversation about how much information we get on that registration form. And that information might expand to include some level of understanding shape and aerial extent of that flow line system. Sorry, that gathering, that produced water, I'm going to call it a produced water transportation system. Also under the 300 series, there are existing rules that cover tank gauging. Again, I would assert that those rules are out of date compared to modern technology, and the intent is to bring those up to date by allowing for different kinds of tank gauging methodologies that are widely in use today, but not really covered by our rules. In the 600 series, our rules are pretty silent about requirements for identifying valves and locations and maintenance of those valves, and in certain cases requiring check valves. Again, something that Stuart, Mark, Elise can talk about much more than I can, but that's something that we have identified that we think needs to be updated. And finally, the 700 series are our financial assurance requirements, and we think we would be prudent to include financial assurance requirements for these E&P water transportation systems. Anything you want to add? Okay. So that's the overview. And I think with that, I'm going to turn the floor over to y'all. We did have a microphone stand when I pass the microphone around. Is the room wired? So the room is wired. I guess we maybe don't have to have a microphone, but it might help for people to be heard. Yes, sir. It's all recorded. I wouldn't answer the door for a few days.
Again, Jeff Seaman, somewhat maybe far afield, but to what extent is your team coordinating with what the PUC is contemplating and mindful of what their potential or promised rulemaking will look like?
So I'm going to actually let Stuart and or Mark answer most of that question. So for those of you who don't already know this, there are some jurisdictional boundaries to COGCC's jurisdiction and jurisdictional boundaries to the PUC's jurisdiction. In a perfect world, they would line up perfectly. In the real world, maybe less than perfectly. And so we have been coordinating, and I'll let Stuart or Mark talk about that. We also, one of the governor's recommendations was that COGCC would ask for a review of some of our rules by an organization called, the acronym is SOGRA, which stands for State Oil and Gas Regulatory Exchange. But we are in the process of making that request. And one of the things we might ask of them is how other states are handling, in particular, I think the thing that's changing most in the industry right now are much more transport of oil, liquids, off location to a centralized facility rather than storage tanks and trucks. And I was going to say, I'm relatively certain that other states are experiencing similar trends and have maybe looked at regulating those lines, or how they've thought about regulating those lines. So I think we'll engage in a conversation with them about that. And PUC will be part of that conversation too. But let me have Stuart fill you in a little bit on what we've been doing.
Well, a tidbit of history. Stuart Ellsworth, engineering manager at the commission. A tidbit of history is that we have been engaging with both PHMSA, the federal regulatory agency over pipelines, and we've also been engaging with PUC. We've approximately been able to meet with them the last couple years on a quarterly basis, trying to discuss many of these relationships between the three organizations. The biggest thing to kind of frame is that PUC is the gas pipeline agency here in Colorado, or at least they have a delegated authority of these gathering lines from the federal government, and oil lines are covered by PHMSA. That's kind of a pretty broad characterization. And then we have the flow lines, those lines associated with raw product. And Mark and Elise are the ones that have been attending and engaging in those meetings. So that kind of sets a framework that we are discussing our relationship between that transfer point from the raw product flow line into these various gathering systems for transportation of the product. Mark, is there anything else you want to?
Yeah, I'd just like to mention that there is an API standard, API RP80, which is referenced in the rules, and that, I guess, by the federal government. The reason that standard was developed was to help distinguish where these transitions occur, where does gathering start, and where does it end, and where does transmission begin. And so we've talked about possibly referencing that document in our rules. In that document, they give lots of different examples in the appendices of what different systems look like and how you would interpret those. And I guess there's possibility that that standard will be updated in maybe the near future. So that's something, if you're on an API committee or have interest in that, you might want to follow along.
Mr. Matthews.
Yeah, along those same lines, this is a follow-up to Jeff's question. You know, in trying to define flow lines, the 800-pound gorilla is the question of jurisdiction. And RP80, the regulation you're referring to, is being revised, and God knows when it'll be finished. What the heck are we supposed to refer to as the definition of a flow line that is within COGCC jurisdiction. Is it the production facility? Is it the first piece of equipment? Is it the separator? Is it the custody transfer point? None of those seem to be wholly adequate in our group discussion. So any insight you can give us would help us avoid a lot of banging our heads against the wall.
Yeah, I think we've tried to address that in the guidance document that's been out. And so I would encourage everyone to look through the operator guidance on the flow lines, covers a lot of information. And I think the NTO and the FAQ also give some additional insights. And through this process of the public hearings and the rulemaking and the comments, I think we can clarify a lot of things that maybe aren't obvious to everyone right now.
Mr. Walker.
I got the microphone.
I have the power switch.
The battery's dead. Mark, I kind of want to respond to how you just answered a little bit on definitions of flow lines. I think that's where some of the confusion comes in. And trying to bring all these together into one finite definition is part of the problem. So there's places we can go to get ideas on how to define a flow line. I don't think all those documents, I think they help muddle it, my opinion, but there you go. My other concern is on the potential change on the 700 rule. And you're going to hear this 1,000 times because it's absolutely true. Yuma County gets hammered first when something new comes out that could be costly. And as I've said, Yuma County wells, the 4,000 wells in Yuma County average 16 MCF a day. And if we're making the wonderful amount of $2 per MCF, that's $32 a day. So yes, I get very concerned about economics of that. With that, there are water collection systems out there. And when those water collect, I don't know if you're going to be looking at some form of grandfathering or something along that line. Us little guys can't get bonds in Colorado. We can't. We have to put up the cash. When those water gathering facilities were built, they were built under certain economic forecasts, cash flows. You know, what's it going to cost me to keep this thing in line? In addition to that, those systems, they eliminate pits, they eliminate tanks, they eliminate trucking. And so when you're thinking about financial assurance on these water gathering systems, I'd be careful not to penalize them. I also might think about some grandfathering so that future systems can take into consideration the cost of putting up cash for a bond. Thank you. I'm hanging up the microphone.
Thank you. Mrs. Zeller.
So Christy Zeller with the La Plata County Energy Council. And one of the concerns some of our operators have is we produce about 75% of the state's CBM. And the produced water lines, it's not a hazard. It's more of if you have a leak environmental, is there going to be anything that can be done to somehow address produced water lines for CBM?
We are mindful of the distinction in produced water generated by CBM versus other forms of production. We have worked with some of the operators in the San Juan Basin with respect to their water gathering transport systems, I think successfully. And that's about as much as I can say. I mean, I understand what you're saying. Those are places where variances to the existing rules, integrity requirements have been granted due to the size of those systems and what is being transported in them. And I think the current intent is to bring in, as I said previously, allow for those different integrity monitoring systems by rule rather than by variance. Zoom participants? Nada? How many do we have? Can you tell? Okay. Oh, thanks. All right, looks like we have satisfied everyone. So we can stick around. We can sort of make this less formal and hang around for a while and chit chat. But needless to say, you know how to find us. We're happy to try to get together in smaller quarters, I guess, if that's desirable, to the extent that our resources allow. Happy to do that. Look forward to thoughts and inputs. And there's one more question or comment.
Kim Sanchez, Boulder County. At the COGCC hearing on the 11th of September, Commissioner Overturf made several suggestions to broaden the scope in a number of areas that she thought the rules should also include. I'm just wondering if those are also going to be included in the rules. I don't see them specifically listed on the scoping document.
The scoping document is where we plan to make rules right now.
So no, you don't plan on including her suggestions, or you do plan on including her suggestions?
First of all, don't recall specifically her suggestions, but if it's not captured in the scoping document, I think it's probably not on the short list.
Okay.
All right. Thank you all for being here.